Honorable Justice Dipankar Doctor, Honorable Justice Ashim Rai, Professor N.K. Chakraborty, Mr. Siddharth Sharma, Swati Kapadia, Prabhu Gupta, Soumya Ranjan Dikshit, esteemed members of the faculty and dear students. Ladies and gentlemen, I extend my gratitude for the invitation to be part of the Nani Palkhivala Memorial Conclave. It is both my pleasure and privilege to be here today. Before I delve into the basic structure, I have to make a few acknowledgements and give a few personal views which I think is important for the students. Of all my expertise which was mentioned, you might have noticed constitutional law was left out. And here I am today speaking on the basic structure of the Constitution, which is why I think I need to tell all the students that as far as I'm concerned, it's our Constitution which is the most important book to have by your side while you read and practice law. It's one of the books where every article needs to be read more than once, rather I'd say repeatedly. Because the Constitution, as Justice Doctor said, is a very evolved, living organism. It has lent itself to innumerable interpretations, innumerable discussions, and involves, most importantly, the common citizen, who is actually the real stakeholder in the Constitution. Constitution gives us the aims, the purposes for which we should strive and live. It is really the guiding light for us. And I must confess that even today, not a day goes by that I do not look at some part of the Constitution. So yes, I consider it, though not recognized as part of my expertise, a book which stimulates me all the time. Now, I've had actually the benefit of having worked with 4 senior lawyers quite closely on constitutional matters. And I need to pay my debt and make my acknowledgements before the students. Because in the profession, you will learn from the seniors. They are, and this is in order of my gratitude, first would be my first senior, Mr. Dipankar Ghosh, who's no more. The second would be Mr. Somaraditya Pal. All of you would be familiar with him and his work on constitutional law, service law, and contempt, the law of contempt, who is sadly also no more with us. And two others who live, and I'm grateful that they do, are Mr. Anindo Mitro and Mr. Shobhinath Mookherjee. And it is with them that I have had several discussions on constitutional issues, which actually gave me the confidence to come and speak here today. And lest I forget, I want all the students here to remember that your institution is today recognized as one of the premier institutions imparting the knowledge of law. Be proud about it. Remember that once you step out of this institution, even as a lawyer, your first duty is to ensure that the quest for justice, that you assist in the quest for justice. You are first an officer of the court, then you represent the client, and if you hold or a brief for the government, as Justice Doctor would remind us, you owe a duty to the citizen. Now let me say a few words about Mr. Palkhivala, the basic features of the Constitution, and about the two essays which were presented today. Not many of you know that Mr. Palkhivala had a very close connection to Kolkata. He was on the board of directors of the Statesman. He did visit Kolkata regularly and was here for the budget speech. It was an iconic event which towards the end had, from actually business houses just providing a venue, shifted to the Netaji Indoor Stadium. And it was used to be packed. Second thing about Mr. Palkhivala, he was like another doyen of the bar, Mr. Ashok Sen, comfortable with any branch of the law. And he had amazing powers of assimilation. So even in the most complicated of cases, his mastery of facts was amazing. And he did that in a very short duration of time. And I had the privilege very early on in the profession to assist him in a case which involved a foreign arbitration, which involved Air India, and there it was what all of you law students would know, Section 44, 45 of our Arbitration and Conciliation Act, which provides for a reference to the tribunal even in foreign seated arbitrations. It was Section 3 of the Foreign Awards Enforcement Act of 1973. So it was Section 3 which provided for a mandatory stay, unlike Section 34 of the then Arbitration Act of 1940. So it was one of those matters where a suit had been instituted in the Calcutta High Court, and he was arguing for stay of such proceedings. He was for the foreign party. He also appeared in the Supreme Court in that matter. The third thing about Mr. Palkhivala was that he always had very encouraging words for juniors, which at times are missed today, because quite often in a litigation it's the junior who's burnt the midnight oil. And I find it absolutely distasteful when that is not acknowledged. And last, if I may, I'd forgotten this. Mr. Palkhivala usually argued without having notes. He didn't need them. It's chits which would go up to him in case his juniors felt he was arguing a point which he had discussed but had forgotten to place before the court. And the chit would again prompt him to argue. And look at us, we all need notes before us, even when we address a group of students. He was that high caliber. Now on the basic structure doctrine, I want to actually quote a passage from Tempton Andhyarjuna's book, who was actually assisting Mr. Sirva in that matter. Now all of you who have read the Kesavananda Bharati case, you might be forgiven for thinking that all 13 judges have said 13 different things. It's pretty difficult to call out a ratio. You might feel that way. Or certainly, what is the view of the majority? Now, all that I want to say is, don't feel disheartened if that happens, because in his book, Mr. Andhyarjuna says this: the view of the majority, which was signed by 9 judges, 4 didn't sign, the view of the majority cannot be the ratio of the Kesavananda judgment. This is what he says, I'm quoting. If a ratio had to be extracted from the 11 judgments in the Kesavananda case, it could not have been done in the manner of asking judges to merely subscribe to the view by the majority paper on the day of pronouncement of the judgments in court. Deriving a ratio from the 11 judgments could have been done only after a full hearing by a later constitution bench to which the petitions were remanded for disposal according to the unanimous order of the court. No later constitution bench was convened to dispose of the petitions. It is fallacious to say that the view by the majority was that Parliament could not amend the basic structure or framework of the Constitution. That was only the conclusion of one single judge, Justice Khanna. 9 judges, by merely signing a statement, could not create a view by the majority, when 6 of the 7, Chief Justice Sikri, Justice Shelat and Justice Mookherjee, Justice Hegde, Justice Grover and Justice Jagmohan Reddy, who were in favor of limitation on amending power, had not subscribed to the limitation of the basic structure for the same reasoning and in the same sense as the 7th Judge, Justice Khanna. But yes, this landmark decision has been the subject of a huge amount of criticism, but has been thankfully interpreted by the Supreme Court in several decisions to identify the basic structure of the Constitution and thereafter to strike down amendments or legislation, ordinary legislation. As you all know, the attempted review of this judgment also ended disastrously after 2 days of hearing. So it has stood the test of time and quite unequivocally, thankfully for the citizens of India, ensured that the judiciary remains the custodian of the Constitution. Now I will proceed on the basis that most of us here have either read or attempted to read the Keshavananda Bharati case. It is in many senses a classic. So I used to be a student, undergraduate student in economics at Presidency College. It was then part of Calcutta University, hadn't become a university by itself, and we had one of the finest economics department, economics faculty. It's one of the reasons why I chose Presidency over St. Stephen's. And the head of the faculty used to be a gentleman called Professor Deepak Banerjee. One of the referred texts was Value and Capital by Professor Hicks of Oxford. So he gave us this book to read, suggested that we read it. Most of us didn't, some did. So about a month later he asked if anyone had read it. And the more serious students in class, who we also refer to as geeks, put their hands up. And that was the one mistake, because the second followed immediately thereafter. I said, did you understand it? And they said, yes. That made us feel really bad, those who hadn't read it. But the next was, so tell us what you understood. And we were very happy once that question was put, because there was no answer. And they were told, look, it is a classic. You can't understand it if you read it once. Read it, reread it, live it, and you'll understand it, and you'll know how to apply it to questions that we set. So this is what I wanted to say about this landmark judgment. You'll find it being referred to very lightly in conversation. But please read and reread it. Because, as I said, it has stood the test of time and is actually one of the bright hopes that we have for our nation. Its survival and its interpretation, the way it's proceeded up to date, is important. Now, to recent developments I want to talk about. In the Supreme Court, many of you, and Justice Doctor will kindly forgive me, I'm referring to his territory here, arguments are being advanced on the electoral bonds case. Now, all of you are aware that free and fair elections has been held to be a basic structure of the Constitution. And that is one of the points which is being argued by Mr. Sibal. Now another election case, the Kuldeep Nair case, says, well, you can't invoke this doctrine, the basic structure, for ordinary law, which related to one of the issues involved there was person seeking election to the Rajya Sabha from a particular state. Did he have to be a resident, a domicile of that state or not? And that too was a constitution bench. So keep your eyes and ears open as to what is held ultimately on this issue by the Supreme Court. To my mind, as of now, this Nair's case has not yet been cited. I hope it is during the hearing. I might have missed a hearing or two where if it was cited, but to my knowledge it has not yet. But the Supreme Court will certainly have to resolve this conflict because Kuldeep Nair's case was also a constitutional bench judgment. Now, the second recent thing. Democracy is the basic structure of the Constitution. Free and fair elections is also a basic structure of the Constitution. Punnaswamy's case came before Keshavananda Bharati. After Keshavananda Bharati, several decisions have come which adopt Punnaswamy and say that Article 329, 243 ZK, 243O, which start with the words a non-obstante provision notwithstanding, and refuse to entertain a judicial review once the election process had been set in motion and had yet to be concluded. And these are either Constitution bench judgments or decisions by a three-judge bench. Very recently, we had Justice Amanullah speaking for the Supreme Court after considering these judgments, saying in a given case, we can have an Article 226 to be invoked. Now that is now a burning issue also before the Calcutta High Court relating to panchayat elections, because there are writ petitions pending challenging the panchayat elections. So again, keep your ears and eyes open on this. Last but not the least, I told Justice Doctor, he is of course been very conscientious, much more than I have been, to have read several essays. I had read none till I came here, because I didn't know they were available. I might have asked for them. But I did get to know about the contents of two. And I must compliment both of you for absolutely excellent work. It's at so young an age, you have tickled several minds, and that is really what you need to do when you are in pursuit of excellence. And remember that as long as this trait lives in you, you are bound to succeed in the profession. There is no substitute to hard work in the profession. And as a senior advocate, from the dais today, I want to make one statement to all the students who are gathered here. Please feel free to get in touch for any advice that you need. Because as Justice Dotto said, the choice that you make after you graduate has to be an informed one. So if you do feel that you need some assistance in your decision making, please feel free to contact me. The details are there with your institution. And I must tell you one thing, even before I became Advocate General, I had offered my services to the institution and left my contact numbers. I used to feel very bad when everybody else other than me got invited. And this is only the fourth time that I'm invited to this gathering. And I'm indeed, I extend my gratitude, as I said, and I'm really privileged that this has happened.